Welcome back to Chapter 2, and we're actually going to look at the First Amendment here. Here it is, and I'm going to jump to the middle part that's been made bold. Congress shall make no law abridging the freedom of speech or of the press. Now, in the 14th Amendment, which was passed a good bit later, the First Amendment was made to apply to the states, and then, of course, through the states to local governments. So you can now read this: neither Congress, nor the state legislature, nor any city council or board of county commissioners shall make a law abridging the freedom of speech or of the press. And it's this language that has been applied to protect sexually explicit material in a variety of contexts. The Eighth Circuit Court, which is a court of appeals that serves the middle part of the country — we'll see a map of the circuits a little bit later — said in a 2006 case, although one may find sexually explicit material tasteless and even immoral, it is constitutionally protected so long as it is not obscene. And we'll talk about what obscene means in just a minute. But first, a basic principle. If you have to go to court to defend your zoning ordinance, let's say that your zoning ordinance only allows pawn shops in one zoning district, and there aren't many areas zoned that way, and it isn't a particularly desirable zoning district. And I don't mean to pick on pawn shops. I'm just picking a use that might get zoned in a strange way. And the owner of a pawn shop who wants to open in a new location brings a lawsuit. When you go to court to defend that zoning ordinance, there is a presumption of validity. The court automatically presumes that your ordinance is valid. And if the case actually goes to trial, all that you have to show, if the pawn shop owner says, well, this is unfair, it seems unconstitutional, it's irrational, all you have to show is a rational basis for it. And if the members of the city council determine that they think pawn shops should be pretty restricted because they may attract shady characters and they don't want kids encountering these shady characters, or they believe that the very existence of pawn shops may encourage people to pawn the tools they need to carry out their professions, that you may or may not agree with that position, but that is an entirely rational basis for city council to make the determination that we're going to limit where pawn shops go. And remember, these ordinances get the presumption of validity. Both attorneys. What does presumption of validity mean? Let's say both attorneys show up in court and they've both been at the same party the night before and they both fall asleep. Now, the judge is going to get pretty ticked off at this, but assuming that the judge is glad to get an easy day, the judge can look out and say, okay, neither side did anything, and the city gets a presumption of validity, so the city wins. That's the way the presumption of validity works. But when a regulation interferes with somebody's constitutional rights, and here we're talking about constitutional rights under the First Amendment, the courts apply a rule that's called strict scrutiny. What does that mean? Well, basically it means that the presumption of validity is reversed, or it's turned on its head, and you basically go to court with a presumption that your ordinance is unconstitutional. And probably the leading case dealing with this issue, certainly not the only one, is Booz v. Berry. Washington, D.C., there are a lot of embassies. That's a big part of the economy of Washington. The leaders in Washington decided at some point they did not want to insult people in the embassies. And so they passed an ordinance that prohibited within 500 feet of an embassy a sign that would bring public odium or public disrepute on that government. Here we have the royal Thai government, and we put up a sign that says, I hate King Bhumipol. He should have resigned many years ago. He's an old guy. Get rid of him. You can't do that under that ordinance. It went to the Supreme Court, or maybe you put up a sign outside the Russian embassy. It went to the Supreme Court, and the Supreme Court said, that ordinance is unconstitutional. You can't do that. You're regulating signs based on what they say. So here's the conundrum. How do you define a sex business to regulate it separately from a non-sex business? I mean, Barnes & Noble has art books with complete nudes in it. It has marriage handbooks that tell you how to have sex. It has illustrated marriage handbooks that tell you how to have sex. It has erotica. It has all sorts of things that could arguably be classified as sexually oriented. So how do we distinguish Barnes & Noble from a sexually oriented bookstore? Well, it's how much of this material there is in all probability, and therefore we get into regulating places differently based on the material that is there. So it is impossible to define, or take a simpler example. How do you distinguish a strip club from a nightclub with comedians or female comedians, say? Well, it's based on how much clothing they're wearing. We'll talk a little bit later about nudity and the type of material that they present. So we're making distinctions based on the content of the message. And therefore, our ordinance is essentially presumed to be unconstitutional. That's a tough problem. 1986, the Supreme Court crafted a rule that solved that problem to an extent. The Supreme Court said, zoning ordinances designed to combat the undesirable secondary effects of, read this, sex businesses, are to be reviewed under the standards applicable to content-neutral time, place, and manner regulations. Are people allowed to carry protest signs through the middle of town saying, impeach the mayor? Absolutely. You don't want to try to stop that. Can they do that right in the middle of Main Street without moving and completely block traffic there? No, you absolutely can prohibit them doing that, provided that you give them some other place or some other time that they can carry on those activities. Those are content-neutral time, place, and manner regulations, assuming that you're not trying to regulate the content of the placards that they're carrying. And those have a level playing field when they go to court. There's no presumption of validity, but there's no presumption against it. And what the court's saying here is if you show that the purpose of your ordinance was combating these negative secondary effects, and we'll talk about what that means in a few minutes, rather than censoring what's going on in the business, then we'll give you a level playing field when you come into court. That's some heavy material, but we'll come back to it, and that concludes this chapter. Now, in the next chapter, we'll look at some aspects of sex businesses that don't have constitutional protection and try to define a little further which aspects of sex businesses do have such protection.